appeal Dryden for others, and Johnson Matthey Plc.
Yes, Mr. Weir.
Well, may it please my Lady President, my Lady and my Lords, I appear on behalf of the appellants of my learned friend Mr. Kerr, and my learned friend Mr. Kent of Queen's Counsel appears on behalf of the respondent with Mr. Houghton. Your Ladyship will see from the statement of facts and issues that there are two issues before the court today. First, do the appellants have an actionable claim for damages for personal injuries? Secondly, if not, are they entitled to recover damages for economic loss pursuant to an implied term of the contract of employment, alternatively in negligence? My Lady, that's set out in the core bundle in the statement of facts and issues, the pagination being described as MS, which I understand to be memory stick. And I can report,
indeed what it, not manuscript.
My Lady, no. And knowing, my Lady, how important it is to have pagination in order, I can report that my learned junior has sought to ensure, and I believe we have ensured, that the electronic pagination is identical in all respects to the pagination in the bundles, to which end I shall refer simply to, if it's an authority, the authority bundle, the tab number, and pagination.
Well, that's no mean feat.
Well, I hope, my Lady, it may be that someone catches me out somewhere, and I know my learned friend has introduced an additional volume which only comes in PDF.
Ah, right.
But, so certainly so far as concerns core bundle and authorities bundles 1 to 7, I hope this will work. My Lady, can I start with the first issue? Do the appellants have an actionable claim for damages for personal injuries? As my Lady, Lady Hale, described in Gregg and Scott, it's now Hornbook law that damages is a gist of the action in negligence. And that gives rise...
I got that from somewhere else.
Absolutely, my Lady, it being Hornbook law.
I think Professor Stapleton may have said something like that.
That's quote unquote, my Lady, but it matters not. Two questions arise as a result of asking or noting that point. First, how do the appellants describe or characterise their damage? And secondly, as such, does it constitute damage as the law defines the term? And can I start with the appellant's case as to the damage they say they have sustained and when it was sustained? In these cases, an admitted breach of the common law duty of care caused the appellants to suffer platinum sensitisation. And that point was reached prior to the appellants undergoing skin prick testing, which served to confirm or identify that diagnosis. Platinum salts sensitisation constituted a physical change to their bodies. And at that point in time, the die was cast. They were in jobs that made them liable to be exposed to platinum salts. Further exposure to platinum salts was likely to cause their asymptomatic sensitisation to become symptomatic. Symptomatic sensitisation being otherwise known as allergy. And I'll just give you the reference in Dr. Rudd's report. It's agreed, core bundle 385. So either the appellants carried on working in their jobs, which could happen, for instance, if they raised a false negative on skin prick testing. And then they would likely go on to develop symptoms of sensitisation. And it being possible to raise a false negative is also set out in the joint statement of the medical experts. That's core bundle 399, paragraph 9. Or, as actually happened, they test positive on skin prick testing, and to mitigate or prevent the asymptomatic sensitisation from becoming symptomatic, they are promptly removed from work in the red zones that exposes them to platinum salts. Either way, they lost. From the moment of sensitisation, the appellant's bodies were less useful or less valuable to them. The appellant's capability for work, a key ingredient of their ordinary lives, was measurably reduced at point of sensitisation. But a different way, as we'll see from the case law, they were materially worse off. So at the point of sensitisation, they were at risk of developing symptoms directly as a result of their platinum sensitisation, and this made them measurably worse off precisely because it impacted upon the use that they could make of their bodies. And none of what I've said so far is really arguable. As a matter of fact, of course, the respondent challenges the legal consequences of this state of affairs, but the fact that they're worse off for being sensitised cannot sensibly be challenged. It was exactly how the system worked, there being a collective agreement, as the court will have seen, under which they were regularly tested, the purpose of testing being to catch them at the point of sensitisation as opposed to allergy. So all that I've sought to set out cannot be in dispute. And in the appellant's respectful submission, that constitutes damage. So that's at the point of sensitisation. So damage constituting the gist of the action is not platinum allergy, a condition they did not, as it transpires, develop. It has to do with the actual impact at the time of sensitisation on the use the appellants could make of their bodies. It relates to the loss of amenity or capability they experienced on sensitisation by virtue of the real risk they now faced of going on in the ordinary course of their lives to develop symptoms. The ordinary course of their lives would be, I'll wake up tomorrow and just like today, I'll go to work. And I'll go to work in the same red zone I was working in today. That's the ordinary course of life for them. Termination of their employment in the red zone and subsequently termination of their employment for Johnson Matthey only happened, one, after the appellants were sensitised, and two, as a direct result of the appellants being sensitised. And that is why it was an act of mitigation after the accrual of the cause of action. Now, to the extent that it's to be taken into account as a step that was bound to happen, which is really the underlying premise of the decision at first instance in the Court of Appeal, and equally it has to be recognised that the appellants were at the time of sensitisation bound to face the financial impact of termination of their employment, first of all in the red zone, subsequently for the employer. And that too can be factored in to what constitutes material damage for the purposes of completing the cause of action in negligence. So, referencing the Latin for damage in this context, they were, if I can put it this way, damn them if they do, and damn them if they don't. My lady, can I turn now to the way in which the courts have defined damage? And that is a two-stage test. First, and I should say, I am here seeking to draw from the authorities our understanding. We can always play with the authorities and identify other forms of word used, but this is how we seek to synthesise the test as drawn from the case law. First, there needs to have been a physical change in or to the claimant's body. And secondly, as a result of such physical change, the claimant needs to have suffered what we call, from the case law, material damage, a term which is synonymous with other terms such as materially worse off, measurably worse off, real damage, actual damage. It's not an issue in this appeal that the platinum sensitisation constitutes a relevant and sufficient physical change. I'll just give you the reference in a respondent's case, paragraphs 28A and 33, core bundle 104 and 106. Lord Reed is going to turn it up. I'll invite the court to kindly go. So that's core bundle 104. Right at the top, whilst it is a bodily change, and then indeed over the page to paragraph 33 has a heading, mere bodily change, starting accepting that at the moment of first sensitisation the appellants have undergone a bodily change. And Lord Justice Sales at paragraph 30 in the court below, that's core bundle page 32, described it as analogous to the development of pleural plaques, which were themselves described by Lord Hope as a form of injury. In Rothwell, a case to which we'll go in due course, para 49, 1/3/512. So the case doesn't turn on physical change, the case turns on what is meant by material damage. Can I now, my lady, turn to the material damage test? And can I give a pithy summary from Lord Pearce? So this is in Authorities Volume 1, in the cartilage case, 11464. This is the key section of the key judgment in cartilage, namely the judgment from Lord Pearce. And in the middle of page 464, just above the middle, the court will see, so it's 464, the court will see it is a question of fact in each case, and then after that, whether a man has suffered material damage by any physical changes in his body. I'm just going to leave it there. I'm not going to read the rest of that passage, which is important out at this stage. But that's where the test comes from. That's a fine description of that which is in issue. My lady, the first submission I make is the court is addressing the impact of the physical changes to a claimant's body on the claimant. In other words, there is a distinction to be drawn between the claimant's body and the claimant for this purpose. What is key is the effect of the physical change on the claimant. The distinction between, on the one hand, the physical change or injury, and on the other hand, suffering of material damage by the claimant, is again made by Lord Roger in Rothwell. And can I go to that, please? 13523, paragraph 87. So that's 523. Paragraph 87, Lord Roger describes there being three stages. The first stage is not an issue, as you can see in 87, negligent act or breach of statutory duty by the defendant. And it continues, which, 2, causes an injury to the claimant's body, and 3, the claimant must suffer material damage as a result. So the test is not whether the physical change or injury is material, but rather whether it's caused the claimant to suffer material damage.
And injury there simply means a physiological change.
Injury, bodily change, physiological change. We have in this little area, my Lord, interchangeable wordings. I think a point that Lord Dyson picked up on when we go to look at the case of Carder. So when I say this is the test, I recognise that there are other ways in which it's been formulated, my Lord, yes. Second, my lady, may I make this submission? The courts have found it valuable to approach the question of the impact of the breach of duty on the claimant in the case of a personal injury through a bodily change by asking the question, is the claimant worse off? And there is the clearest of statements to that effect from Lord Hoffman in the Rothwell case. So we're still in 1.3, and here we're at 501. 501. Paragraph 7. And there is a lot in paragraph 7. It may not be long. But can I start, nevertheless, part way down? Damage in this sense. Damage in this sense is an abstract concept of being worse off, physically or economically, so that compensation is an appropriate remedy. And can I read how Lord Hoffman elaborates on that? It does not mean simply a physical change, which is consistent with making one better, as in the case of a successful operation, or with being neutral, having no perceptible effect upon one's health or capability. I emphasise the word capability, but come back to it later. But for these purposes, Lord Hoffman is making the point, entirely on all fours with the submissions so far, that it's not enough to say, is the injury itself material? Because in an operation, the injury is pretty material. But it's what's the effect of the injury on the claimant in an operation? It's to make the claimant better. Put to one side issues of this trespass to person for which there's consent, so it's not trespass to person, but the sentiment that Lord Hoffman is seeking to get across is there. It's not enough just to look at the injury. You're trying to understand what is the effect of this injury on the claimant, this bodily change injury, however you want to call it.
Well, I suppose you could say that if the resulting damage was material, it meant that the change would be material.
My Lord, you could, yes, absolutely. I mean, there are different ways in which one can put it together each time. It's not that one way is the perfect way. It's that these are routes by which the higher courts are seeking to help practitioners and indeed future judges, as in this case, to get behind words like material damage and give them substance and meaning so they can be applied to new scenarios. And that's the purpose of this part of the analysis from Lord Hoffman, is to get back to the claimant. What's the effect on the claimant? And that is a test which mirrors that for economic loss. See, for instance, Lord Hoffman in the nigh credit case, which I can take you to briefly. That's in 324, 1329. This was a post-Samco case dealing with pure economic loss. And at 1329 D and E, you will see Lord Hoffman says what he must show is that he is worse off as a lender than he would have been if the security had been worth what the valuer said. And down to the last sentence of that paragraph, that is, he is worse off than he would have been if it had been correct. Actually, following on from Lord Justice Mustill, I'll just give you the reference in Bell 14546, where he considered that the failure to see that these steps were taken promptly meant the plaintiff was actually and not just potentially worse off. I'll come back to the Bell case in due course. It's a case of solicitor's negligence for failing to protect a divorcing husband's interest in the family home. He then divests himself of his interest in the family home the solicitor is at fault for failing to put on a trust deed or mortgage to protect the agreement that he should have a 1/6 interest in the proceeds when it's sold. And my lady, it is to be noted that Lord Justice Sales in the court below nowhere seeks to address the question whether the appellants were worse off. And indeed, my learned friend for the respondent eschews such a test. See his case at paragraph 72, Core Bundle 118, in which he suggests that what Lord Dyson had to say in the case of Carder was not relevant to this issue. When we turn to the case of Carder, which is back into volume 1, tab 9, it is this test that Lord Dyson, with some force, considers to be, his words, the only relevant question. This is 19640, 640. It's paragraph 22, but it starts at paragraph 18 under a heading, what is damage? At this point in time, Lord Dyson is not addressing the issue of material contribution, which was the issue which he moved on to. This was an asbestosis case, and an issue arose as to whether there was sufficient material contribution from the defendant's small period of causing exposure to asbestos to the claimant who was exposed for long periods elsewhere. But before we got to that, which starts with the heading, material contribution at paragraph 23, he references what is damage, and in due course I would invite the court to read 18 to 22, but for now I simply go right to the end of 22. The use of labels to describe medical condition may be convenient, but it must not distract attention from the only relevant question, namely whether the claimant is materially worse off as a result of the alleged tort, i.e. whether he has suffered damage. Lady, may I make a third submission as follows? A person can be worse off without having any symptoms. That is the ratio of cartilage. See Lord Pierce, 11463. Can I again invite the court to turn that up, please? So this was the case, as your ladyship and lordships will know, in which the plaintiffs had developed pneumoconiosis, albeit at a time when they did not know they had developed pneumoconiosis because they had no symptoms of pneumoconiosis. Yet they had suffered it because subsequent x-rays confirmed they were diagnosed with pneumoconiosis. And the timing of the x-ray cannot give you the timing of the damage. That would be fortuitous in the extreme. If you're x-rayed today and shown to have a condition, the overriding likelihood is you had it yesterday, and then query how many days, weeks, and months before. And at 463, the last paragraph, you'll see Lord Pierce says, in my opinion, it is impossible to hold that a man who has no knowledge of the secret onset of pneumoconiosis and suffers no present inconvenience from it cannot have suffered any actionable harm. And that being so, there must be something else that comes into play that operates so as to constitute material damage, so as to make the claimant, as Lord Dyson puts it, materially worse off. My fourth submission, my lady, can I then return to Lord Hoffman's description, paragraph 7 in Rothwell, of loss of health or capability. So that was 1.3, page 501. and that was the further exposition of his test that he considered was appropriate to apply, when he gave an example of what wouldn't count as being worse off, something which comes out neutral, having no perceptible effect on one's health or capability. As this court knows, when a claimant has a completed cause of action in negligence for damages for personal injuries, he's entitled to, or she is entitled to recover general damages, otherwise known as damages for pain, suffering and loss of amenity. And in a case in which, per cartilage, the claimant may not have pain or suffering, one turns instead to loss of amenity. Loss of amenity, loss of capability, again, for these purposes, broadly synonymous terms. So a loss of amenity or capability can suffice to constitute material damage to put someone in a position where they are materially worse off.
Are you saying here that there's a loss of capability in that there's a loss of the capability to work with platinum salts?
My Lord, yes, there's a loss of capability to... That is exactly right, and then I would put it also in another way, a loss of capability to continue in an ordinary activity of their lives, which happened for these claimants to involve working in the red zones of a platinum salts factory. That's real. My lady, my fifth submission, when one steps back from all of this, is that this fits when one considers what is the purpose of providing a civil remedy in this context for damages for personal injuries. It is to provide a route to restitution, where the use that the claimant has made of his or her body before the accident has been reduced. That's what it's about. If you've got a stark case of, and I'll come to the example from my lady present in a moment, of loss of a limb, you doubtless will be experiencing pain and suffering at the same time. You may be knocked unconscious, but what you are doing is you are losing the use of your ability to, if it's your lower limb, to walk, to function, to run, to mobilize. It's affecting your ability to use your body in the way that you would choose to use it. The way in which the matter was put by the Master of Rolls Brett in Brunson and Humphrey, certainly for our part we find helpful. It's at 18624. It's a case decided in the 19th century in which the issue was resolved as to whether or not a claim can be made arising out of one accident for damages for personal injuries after having settled a claim for damages to property loss. And the answer is yes, but when you bring your claim for damages for personal injuries, you can only bring one claim. And if your symptoms get worse, subject to provisional damages, etc., you can't come back. And at 624, quite near the bottom, about 8 or more lines up, the plaintiff has brought the present action, as the court see this, on the ground that he has been injured in his person. He has the right to be unmolested in all his bodily powers. And for our part, we find that a helpful and vivid description. And I then turn to the insight of Lady Justice Hale in McLaughlin and Jones, a case having at first blush, of course, nothing to do with this, because we're dealing with psychiatric injury arising out of negligence by defence criminal solicitor for failing to keep his client out of jail. So he loses his liberty and goes to jail and is unhappy at that outcome, and the defendant is equally unhappy and seeks to strike out the claim. But within that judgment, my lady said, and this is at 322-1250,
I often wonder whether council have trawled the law reports to find anything even remotely relevant that any of us might have said
We have.
in order to pray it in aid.
Of course. But, my lady, not just in order to pray it in aid, but because it is valuable in this context. My lady, paragraph 57, loss of liberty is just as much an interference in bodily integrity as is loss of a limb. And if I might seek to infer the intention that my lady had in relation to that observation, it is to recognise that you can just be locked up. You have to lose your limb. You can be locked up, and it's like losing a limb. Why is it like losing a limb? Because you cannot make use of your body in the way you wanted to, you chose to. And that's the insight from that observation that we seek to draw. It fits with the purpose for which damages are awarded in this context. Lady, the sixth admission I make is that the court should strive for consistency and coherence in the law. So far, one hopes, so relatively uncontentious, not least when addressing the law of negligence, causing personal injury, damage, and negligence causing property damage. The two should, so far as possible, march hand in hand. One would expect the approach to damage to property to be consistent with the approach to damage or personal injury. That was the approach taken by Lord Fraser in the Pirelli case. Again, granted, a case that could be readily distinguished, being not about damages for personal injuries, but about a defective chimney. It's at 327, the judgment in Pirelli. It's in a speech with which all the other law lords agreed. And it is at page 1382. And it's part of reasoning by Lord Fraser, in which Lord Fraser applies across the ratio in cartilage to damage to property. Namely that you don't have to know the property has been damaged for the property to have been damaged. And there is a passage from C to D. So 1382, C to D. My lords, I find myself with the utmost respect unable to agree with that argument. It seems to me that there is a true analogy between a plaintiff whose body has unknown to him suffered injury by inhaling particles of dust, and a plaintiff whose house has, unknown to him, sustained injury because it was built with inadequate foundations or of unsuitable materials. Just as the owner of the house may sell the house before the damage is discovered and may suffer no financial loss, so the man with the injured body may die before pneumoconiosis becomes apparent, and he also may suffer no financial loss. But in both cases, they have a damaged article, when but for the defendant's negligence, they would have had a sound one. So the comparison here is directly between property and body. It's not to get metaphysical, it's to recognise an incorporeal element to the claimant for these purposes. The claimant is to be distinguished for these purposes from the claimant's body. There again is a graphic description. In both cases, they have a damaged article. When but for the defendant's negligence, they would have had a sound one.
So on your argument, the loss of earnings which these men may have suffered when they could no longer continue in their existing job is ahead of consequential loss, but it's not actually essential to their case. If, for example, the man gave up the job and secured better paid employment of a different kind, he would still, in principle, have suffered a personal injury, and the only barrier to his recovering for it might perhaps be a de minimis.
My Lord, that is right in that our primary case is our description of materially worse off arises from the loss of capability at the time of sensitisation to continue in his activity of ordinary life, which is to work in the red zone. Full stop. To the extent that the court should then factor in what happens later and say, but the collective agreement says you were never going to get an allergy, then what's sauce for the goose is sauce for the gander. You are going to have, or at risk of having, and in this case have established that you will have financial loss. So we keep that open, I will take the court to steer from the court, if I can put it that way, because these issues ultimately are here to be resolved by this court today, or imminently. But we have a steer that financial loss can be taken into account in determining whether or not the cause of action has accrued. Of course, if it's accrued independently of that which is our primary case, and exactly as my Lord Reed says, it falls to be determined simply as consequential loss or not at all, depending on the facts of a given case. But it's having your body as a damaged article that makes you worse off. My lady, the seventh submission, I think the list goes on forever, I'm pleased to say, and I'm not going to disclose how many points there are. Then you'd be counting backwards. But, my lady, the seventh submission is entirely consistent with the way in which the meaning of damage has been analysed in other property cases. And can I start here with the Orjula case, a decision of Mr. Justice Mance back in 1995. So that's 320, so bundle 3, tab 20. This is a case which I will take the court to twice. The judgment of Lord Mance is relevant to this issue and also to the economic loss claim. This being a case in which, for these purposes, the relevant part to go to starts at page 1167, goes on to 1168. And the issue that arose was there having been a spillage of hydrochloric acid from a container on a shipping vessel. Hydrochloric acid spreads out over the deck of the vessel, but it does not damage the fabric of the deck. See page 1167, end of first paragraph. This was a strikeout case, and you see Lord Mance says, but no such alteration is actually pleaded at present, and I proceed on the basis that there was no alteration to the fabric of the deck. So the question then arose, was this a claim for economic loss, or was there property damage? The property in this case being the ship, the vessel. And Lord Mance refers, the second paragraph of 1167, Lord Mance refers to some criminal cases from which he says he gained some assistance. And he then quotes the first quote in the judgment of Mr. Justice Cantley. In the middle of the first quote, the court will see, in the concise Oxford Dictionary, the court have that, damage is defined as injury impairing value or usefulness. In due course, the whole of this passage, 1167 to 1168, is in play, but can I seek to proceed apace? If you go over to page 1168, to the end of the quote at the top, just delivering a very short judgment, a court for Crown cases reserved, Pollock CB said, we're all of the opinion that the conviction is good. It's like the case of spiking a gun, where there's no actual damage done to the gun, although it is rendered useless. In other words, in the criminal context, that person could be convicted of criminal damage to property, even though the fabric of the property is itself untainted, untouched. The gun has been spiked, but not physically damaged. And the reason that that constitutes damage to property is because the property in question, the gun, is less useful or valuable to the person who owns it. So again, we're not looking at damage to the property and the property is worse off. We're looking at it as worse off for the owner of the property. That was a point made very clearly in a South African Supreme Court case that we footnoted in our appellant's case, which I don't need to go to. And then you move to the return to Lord Mance's judgment at page 1168. The criminal test is thus one of fact and degree, so I'm near the top. Depending on the circumstances and on the nature and effect of what has been done, relevant considerations are whether there has been injury impairing value and usefulness of the property in question, and the need for work and the expenditure of money to restore the property to its former usable condition is material. It seems to me that this guidance is also relevant in a civil context. He refers to Hunter and Canary Wharf at first instance. I will take the court in a moment to Hunter and Canary Wharf in the Court of Appeal, so I'll pass on that part. And just at the end of this section, before the heading, the loss flowing from damage to the vessel, on these alleged facts, I would have no hesitation in concluding that the vessel should be regarded as having suffered damage by reason of her contamination. It's just like the example given by Cantley J on the previous page of the cleared building site onto which rubble is dropped. It's 1167 in the quoted section. The rubble doesn't damage the fabric of the concrete that's the cleared path, but it doesn't do much for the person who owns it, who wants to develop it, to have a pile of rubble on it. So that is property damage, even though the property itself is not physically damaged. That's how purposively the courts have approached the issue of property damage. Can I then go, please, to the Court of Appeal decision of Hunter and Canary Wharf? And I'll stay with the Court of Appeal decision because this is not an issue that arose in the House of Lords. There were other issues in relation to nuisance and the right to claim for damages for nuisance. But the Court of Appeal judgment is 215, and the relevant section starts at page 1012, 1012. It's a short section, I'm pleased to report. So here, the court can see there is a heading, paragraph 7. So I'm at 1012 G to H. Namely, is the deposition of dust on property, as mentioned in paragraph 3, capable of constituting damage to that property? So this is dust on a building. And can we go to 1013 C to D, Lord Irvin representing the defendant, Canary Wharf. Lord Irvin submits that there must be damage in the sense of a physical change in property as a necessary ingredient of a cause of action in negligence, referencing Cartledge and Pirelli. And then E, Mr. Brennan, who appeared on behalf of the plaintiffs, doesn't submit that economic loss is sufficient, and the court is not invited to consider that question. His submission is that the deposit of dust, subject to the de minimis principle, amounts to damage in the ordinary sense of the word because it impairs the utility of the object onto which the dust is deposited. He equates impairment of utility with damage. And then the conclusion of the court's, the judgment of Lord Justice Pill, starts at F and runs down to H, and may I invite the court just to consider that section.
Well, those of us who do the dusting have no difficulty in agreeing with those sentiments.
My lady, just so. My lady, down at H, the key part is the damage is in the physical change which renders the article less useful or valuable. And all this, in our respectful submission, chimes with the meaning of worse off in the context of a person who has undergone a bodily change but is not displaying symptoms. If their body is less useful, or, put a different way, less valuable to them as a result of the bodily change, they are materially worse off, exactly as we see in the context of property damage. And the eighth submission on this issue is that there is also a coherent and consistent approach to identifying the date of the accrual of the cause of action in cases involving a contingency between personal injury cases on the one hand and pure economic loss cases on the other. So again, this is all part of the consistency and coherence of the law. Can I start with the economic loss cases and then turn back to Cartledge and Rothwell being the key personal injury cases? Can I now go to the case of Bell and Peter Brown, a case that I referenced, albeit in passing, at an earlier point? That's in Authority Bundle 1, so that's 1-4. You'll find the Bell case. I think I've already sought to summarise that which was an issue in this case. A lot of these cases involving determining for the purposes of the Limitation Act when the cause of action accrues, but the issue remains the same, which is when does the cause of action accrue? So this being a case in which in 1978 the solicitor fails to put a trust deed or mortgage over the former matrimonial home, but only in 1986 is the property sold. Case in which it could be said there's been no damage until the property is sold. That would be one way of approaching these matters. And indeed it was the approach taken by Mr. Justice Oliver in the Midland Bank Trust and Het Stubbs and Kemp case. Now, that's one way of looking at these matters, but it is not the way that the courts have, save for that outing, consistently looked at the matters. And the way the courts have looked at the matter is always, and this is in a claim in tort, not a claim for breach of contract, always to look for the first occasion in which there has been some damage, in which the claimant's position has been changed, in which there is an effect on the claimant. So if we start at 534, right at the bottom, there's a heading, the claim in tort, just for the avoidance of doubt that we're now looking at a negligence claim and not the claim for breach of contract. That's 534, right at the bottom. And then we go over, and if I can go, I'm in the judgment of Lord Justice Nichols, if we go to 536C, in the middle of that paragraph, Lord Justice Nichols says, he was at risk from the outset. The finding of the court being that the cause of action accrued, as I've already indicated, when the property was transferred across to the wife and no mortgage at that time was put on to protect the husband. He was at risk from the outset. His interest was vulnerable. And then he addresses the argument that this can all be put right in an instant. Because if he contacts his solicitor and notes the problem can be resolved at any time between 1978 and 1986. And he continues, on the other hand, so long as the plaintiff's wife didn't deal with the property, failure B could easily be put right and little expense, and had it been remedied, the failure to lodge a caution promptly in 1978 would have caused no financial loss to the plaintiff. And the start of the next paragraph, he's saying, but that isn't a ground on which to distinguish this case from any other. Because he explains, if you go down to G, the paragraph in G, in considering whether damage was suffered in 1978, one can test the matter by considering what would have happened if, in, say, 1980, the plaintiff had learned of his solicitor's default and brought an action for damages. Of course, he would have taken steps to remedy the default, but he would have been entitled at least to recover from the defendants the cost incurred in going to other solicitors for advice on what should be done and for their assistance in lodging the appropriate caution. The cost would have been modest, but not negligible. So there was the choice for the courts. They could have gone down a line until that contingency, the wife selling the property, materialises. Your damage hasn't accrued, hasn't arisen. You haven't suffered your loss. But it's simply not the approach that the courts have taken. We see, I'll just go briefly to Lord Justice Mustill, that's at 546 for the sentence that I'd quoted earlier, 546C to D. The failure to see that these steps were taken promptly meant that the plaintiff was actually, and not just potentially, worse off. And the same approach was taken in the case of Knapp. And Knapp is at volume 2, tab 18. Knapp was a case in which the homeowner obtained a policy of insurance, but as a result of breach, or negligence I should say, by the insurance broker, the second defendant, it did not cover fire damage. And needless to say, sometime after the contract, there was indeed a fire and there was damage. And the argument was run in a similar fashion by the claimant that his cause of action didn't accrue until the fire occurred, because it was a contingent loss, and until the fire occurs, it hasn't arisen. And again, that was not the approach that was taken by the courts. And can I start with the judgment of Lord Justice Hobhouse at 1129. And after quoting from Lord Justice Mustill in Bell and Peter Brown, he says, from these authorities, the court have that's the lower half of 1129. It's this particular paragraph. It can be seen that the cause of action can accrue and the plaintiff can have suffered damage once he's acted upon the relevant advice to his detriment and failed to get that to which he was entitled. He is less well off than he would have been if the defendant had not been negligent. Applying this to the present case, the plaintiffs paid their renewal premium without getting, in return, a binding contract or indemnity from an insurance company. They'd acted to their detriment. They didn't get that to which they were entitled. The fact that how serious the consequences of negligence would be depended upon subsequent events and contingencies does not alter this. Such considerations go to the quantification of the plaintiff's loss, not to whether or not they had suffered loss. And he then uses a form of words almost identical to that of Lord Justice Nichols. The risk of loss existed from the outset. And he puts it again in similar fashion, right down the bottom. First, he points out the failure creates a risk, and it is this risk which forms the subject matter of the action. And that goes back to what is the gist of the action? Gist of the action here not being platinum allergy. Can I then go to judgment of Lord Justice Buxton, because Lord Justice Buxton addresses again in his own very vivid way the issue of, but this is a voidable policy and it can be tidied up and put right at any time before the fire occurs. 1133 in the middle, it's third new paragraph down, the one starting first. So that was what was put against the defendant. First, if it's to work at all in the way in which it was sought to be used by the respondents, the test has to assume not merely one impossibility, an action at the time of breach, but also another impossibility, that that action took place and made available to hypothesize reactions on the part of the broker and the insurance company at the very same moment as the breach. If there were any period of time, any scintilla temporis between the failure to warn the plaintiffs on the inception of the policy and the putting right of the mistake as a result of the action, then there would have been a period during which the plaintiffs had a voidable rather than a valid policy. A hazard of short duration might be quantifiable only in a very small amount, but the fact that the award of damages is small does not mean that it is nominal. And he there quotes from from Lord Halsbury in the Mediana, who gave the famous example of not having to establish that he used every chair in a room when one of the chairs was damaged in order to recover real damages for loss of use of the chair. You don't have to prove that you were going to sit on the chair tomorrow. It's not nominal, that loss. It's a real loss because your property has been damaged and it is less useful to you. In that case, the chair, and it could be a contract, as we've got here, and it can be your body in the context of damages for personal injuries. So, Lord Nichols was, we respectfully submit, absolutely right when in the subsequent case of Nye Credit in the House of Lords, which is at 324, and at page 1324, D to E, he said, so D to E on page 1324, further, within the bounds of sense and reasonableness, the policy of the law should be to advance rather than retard the accrual of a cause of action. That's plainly been the policy of the courts. It's exactly what they've done in those cases. Lord Nichols' formulation in this case, we can see back one page at 1323, D. In such a case, so I'm in the middle of that paragraph, in such a case, right opposite D, in such a case, this is 1323, in such a case, if the property is worth less than the amount of the loan, relevant and measurable loss will have been sustained at once. That's how he puts it. That's his particular form of words in this particular context. E to F, this is at 1323, it should be acknowledged at once that to a greater or lesser extent, quantification of the lender's loss is bound to be less certain and therefore less satisfactory if the quantification exercise is carried out before rather than after the security is sold. So that's comparable to before the fire or before the wife has sold the property. This consideration weighed heavily in the High Court of Australia in the Wardley case, but the difficulties of assessment at the earlier stage do not seem to me to lead to the conclusion that at the earlier stage the lender has suffered no measurable loss and has no cause of action. So you look for the first point in time when you can identify a relevant and measurable loss, and that is the accrual of the cause of action. Finally, at the economic loss cases, can I go to the case of Law Society in Sefton, another case of the House of Lords. This is Bundle 2, tab 19. This is a case involving an errant solicitor who takes funds from his client. His disgruntled client then brings a claim for payment from the Law Society, which has the opportunity to pay people in cases of hardship, and which has a discretion as to whether to pay in those circumstances, which is subject to judicial review. So it's light touch review, discretion exercised by Law Society. The finding of the House of Lords, the Law Society then seeks to recover damages in negligence from the solicitor or advisor, financial advising was, who advised the solicitor. And so there's a negligence claim which is then brought. And the issue arises as to when the Law Society incurred a loss. Held, the Law Society incur a loss when a claim is made, not when they pay out, not when they agree to pay, but when a claim is made against their hardship fund. That's Lord Hoffman at paragraph 18 and Lord Mance at paragraph 83. This is the case in which we quoted in our appellant's case part of the judgment of Lord Hoffman. Lord Hoffman analyses the cases of Bell, Knapp and others. We see this starting at 1144. The paragraph 22, he tackles the cases of Bell and Knapp. References what Lord Nichols has said in Nye Credit at paragraph 27 about advancing rather than retarding the accrual of a cause of action. Agrees that the approach in Wardley, paragraph 28, rather overstates the case and says it's often the case that a plaintiff who's plainly suffered some damage is obliged to commence proceedings before the full effects of his injury can be known. This frequently happens in actions for personal injury. And then gives his paragraphs 29 and 30. The para 29 ends, the cause of action, however, connotes a legal obligation. Its existence must be determined by rules of law. Para 30, in my opinion, therefore, the question must be decided on principle. A contingent liability is not as such damage until the contingency occurs. The existence of a contingent liability may depress the value of other property, as in Forster and Uhtred. That was another professional negligence claim, in that case in which a mortgage was put on the property without explaining the full repercussions of the mortgage. The claimant's son wanted to borrow some money for his own business interests, and the claimant, the father, had a mortgage slapped on his property without understanding quite what that would subsequently involve for him. Again, cause of action accrues at the outset because the position vis-à-vis his property has changed. Or it may mean that the party to a bilateral transaction, that would be Knapp, for instance, has received less than he should have done, or is worse off than if he'd never entered into the transaction, according to which is the appropriate measure of damages and circumstances. But standing alone, as in this case, the contingency is not damage. That's because in this case, the argument had to be, in order to come within limitation, that there'd be no damage at all until we go right to the end of the process and monies have been paid out. But that's not when limitation, that's not when the cause of action accrues. Cause of action accrued in that case when a claim was made. Because when a claim is made against a hardship fund, the law society is in a different position to the position it was in prior to that time. It's had an effect now. The actions of the errant solicitor have had an effect on the law society, even though that effect could be described then at that point as contingent. You could describe it in that way. You could say, well, we don't know if we're going to pay yet, and we've got a public law right to decide whether to pay or not to pay, but take into account the particular circumstances of the individual who's making a claim. Lord Mance, in his judgment, can I just go for these purposes to paragraph 77, that's at page 1160. So this is para 77, and I'm going to pick it up between F and G. A similar assessment might be made of the risk of future loss of a physical asset, deeds or valuables of which a solicitor was failing to take reasonable care, which had not yet been lost or stolen. But I do not consider that the law should treat purely contingent loss assessed on so remote a basis as sufficiently measurable in the absence of any change in the claimant's legal position or of any diminution in the value of any particular asset. Now, in that passage, Lord Mance actually appears to be considering that it may be that a cause of action accrues on a purely contingent loss, provided it is not on so remote a basis as not to be sufficiently measurable. But in any event, diminution in the value of the claimant's body, the particular asset, suffices to trigger the loss, even though that impact on the claimant's property, financial interest, contractual rights is only reduced by reference to the contingency that is yet to occur. If we go back to the Knapp scenario and say, yes, there's been a change in position for the claimant, that's the finding in Knapp, there's been a change in position at the time that the contract is entered into. But if we ask why, that's relevant and measurable. It's only relevant and measurable by reference to the risk of a fire, which hasn't then occurred. Otherwise, it's something and nothing. It's still in relation to a contingent loss, albeit it is occurring and causes an actual change at that point. And paragraph 78, Lord Mance notes that the English authorities take a clear-cut, though perhaps strict view, and then at paragraph 79, he references the passage that I've quoted from Lord Nichols, and then gives his, what I've described in our appellant's case as a rider to it. Shows, I'm picking it up now at C, 1161, but the passage to which I've quoted from page 1631 seated, and I credit case, shows that Lord Nichols was far from accepting that everything that can loosely be described as detriment will constitute damage for the purposes of a tort claim. Lord Nichols' words are not in any event to be read as a statute. Fair enough. And we don't say they should, but we do see the policy of the law is to advance rather than retard the accrual of the cause of action. My lady, can I now go to the cartilage case, looking at damages for personal injuries, jurisprudence? So that's 1-1.
Is this part of your 8th submission or a different submission?
My lady, it is part of the 8th. That's why I didn't want to get your hopes up by telling you there are only 9 submissions when the 8th might last quite so long. The 8th submission, my lady, relates to drawing a comparison between that which is occurring in the economic loss area and that which is occurring in personal injury. That was the economic loss case law.
So this is the PI.
Now it's the PI bit, my lady. Terra firma. My lady, can I start at 464? So start and end, I think. But can I go back to the middle of that page? And I'd read out at an earlier stage, just above the middle, it's a question of fact in each case, whether a man has suffered material damage by any physical changes in his body. And then I said I would continue. Evidence that those changes are not felt by him and may never be felt tells in favour of the damage coming within the principle of de minimis non curat lex. On the other hand, evidence that in unusual exertion or at the onslaught of disease, he may suffer from his hidden impairment, tells in favour of the damage being substantial. Can I emphasise the words, his hidden impairment? This is an individual with pneumoconiosis who has lost a small amount of reserve of his lung capacity, but it has no effect on him unless you see the expression, in unusual exertion. So he runs very hard. He may discover that he's out of breath rather sooner than he would have been, and he makes him vulnerable, more vulnerable to tuberculosis, no doubt a range of other respiratory infections. So here we have a diminution in the usefulness or value of the plaintiff's body, a hidden impairment, albeit one that's not causing him any problems currently. And in the ordinary course of his life, he may, or may not, but he may, engage in unusual exertion, and he may catch a respiratory infection. And in such a case, he may be out of breath more readily on his unusual exertion, and he may suffer more severe consequences of the respiratory infection. So, just as with Knapp and Bell and so forth, the symptoms materialise later. But the loss occurs now. There's no suggestion, it's to be added, that the physical change in that case, pneumoconiosis, had somehow to have the potential by itself to give rise to further detriment. The reason I put it that way is because when we go to the judgment of Lord Justice Sales, it's how he characterises what needs to be shown. It's core bundle, page 32, paragraph 30. He's just agreed with the core analysis of Mr. Justice J. He says, I agree with this reasoning. On the medical evidence, platinum sensitization is not harmful in itself in any relevant sense. It's a physiological change, analogous to development of pleural plaques in the lungs in the Rothwell case. That was the passage I was referring to earlier. And hence doesn't constitute actionable damage or injury. Unlike the lung scarring from pneumoconiosis in cartilage, platinum sensitization is not a hidden impairment which has the potential by itself to give rise to detrimental physical effects in the ordinary or in the course of ordinary life. Now, if by that he means by itself, of itself, that is not right. Because what is a respiratory infection if it is not an external trigger? You go to pneumoconiosis cases, you have somebody who has a reduction in reserve of lung capacity. Full stop. But that doesn't cause the problem subsequently the claimant would complain of, unless there is indeed an infection out there that he breathes in, an external agent. So it's not a case, cartilage, where of itself, in that sense, of itself, there's locked within that loss of reserve of lung capacity tuberculosis, the subsequent problem. It isn't locked within it at all. Nor should it need to be. It would be bizarre in the extreme if one could only look at cases in which somehow it's locked within it, of itself. What the key is, in the course of ordinary life, what's going to happen? What may happen to this person? What may happen in the future? And if you have a weakness at that point, and in the ordinary course of life, that weakness converts into, that hidden impairment or weakness converts into those symptoms, then that hidden impairment or weakness constitutes damage at that point because it makes you, at that point, worse off. And the learned friend has majored on this issue at paragraph 57 of his case, and that's at page 114.
Paragraph 57.
57, my lord. Page 114. It's an interesting paragraph in which the respondent recognises, albeit with their own formulation with which we disagree, that a physical change at the point of physical change can constitute damage. The whole paragraph can be read, and I'm sure my learned friend will take you to it. And I don't mean in disrespect if I come straight down to the last sentence. A physical change which reduces function, and this is the part now, and or has an intrinsic potential to progress without the need for any further external stimulus from the same toxic agent that first caused it, is an impairment constituting actionable personal injury if it's more than de minimis. That's a sort of part concession, I would describe that as. It's not our case, because my learned friend has had to create the rider to it, that it can only be without the need for any further external stimulus from the same toxic agent, before recognising that at that point in time and before your symptoms, you can have an injury. That being exactly what cartilage has decided.
But I think you, if I follow your argument, would say that this is a physical change which reduces function, in that the person has lost the capability of coping with exposure to the platinum salts without developing the symptoms that are described in the judgments.
Absolutely, my lord. That's our case. our case is that simple. The position has been made complicated by Lord Justice Sales and the respondent's approach in seeking to suggest that you're only now looking at something which of itself gets you to the end point. And this is a way of distinguishing our case, because you wouldn't get to platinum allergy unless you're exposed to further platinum salts. And somehow that's the key that unlocks the door. When there's no sort of reason for so limiting the court's analysis at all, and none given. It's very difficult to understand how and why such an intricate and self-limiting test should be the test to determine whether there's actionable damage, let alone in the circumstance where we're criticised for not making it simple enough. But that is not simple, what's being promoted there, at all. What's simple and straightforward to apply is, are you in a position where, as my Lord Reed says, your function is reduced at that point in time, such that in the ordinary course of living, this is real for you? It doesn't matter whether the ordinary course of living for these individuals happens to involve further exposure, or risk of further exposure to the same toxic agent. That's the position for these individuals, and for others it may be different. But if you're rendered by a defendant's breach of duty super sensitive to the sun, take it away from the narrow remit of this factual case. If you're rendered so that you are super sensitized to the sun's rays, it's the sun's rays which will convert that into photosun allergy, solar photoallergy, or some such. So what? And how could it be said that that person's function, their body, is as useful to them now that they have to remain indoors for the remainder of their life? It's so self-evident in a situation like that that person's function or ability or the value of their body to them has been irreparably altered, just as if they'd been locked in the room that my lady postulated in the McLaughlin case, without a window to the sunlight. Can I now turn to the Rothwell case? So that's 1-3, in which all of this was recognised, by which I mean how a future effect or a future symptom on a symptomless claimant causes current effect to the claimant. And there are a number of passages that I wish to go through. Can I start with Lord Hoffman at paragraph 11? This is page 502, and I'm going to go on to page 503. All that we're about to read in Rothwell is in the context of the House of Lords explaining why there wasn't actionable damage, and there was not actionable damage because pleural plaques do not lead to further symptoms. It's quoted in the Court of Appeal, and I will quote again that Mr. Steinberg very eloquently put it: they're a biological cul-de-sac. So this is all about distinguishing pleural plaques, the context in which all of these sentences arise. But the meaning remains. Paragraph 11, H. If I can go to the judgment of Lord Hoffman, it was not merely that the plaques caused no immediate symptoms, that was also the case in cartilage. The important point was that, save in the most exceptional case, the plaques would never cause any symptoms, did not increase the susceptibility of the claimants to other diseases, or shorten their expectation of life. They had no effect upon their health at all. As the judge put it, and then he quotes approvingly from Mr. Justice Holland, identification of pleural plaques has an evidential rather than substantive significance. Thus, their existence confirms a significant permanent physical penetration of asbestos fibres, but does not add in any way to the resultant disabilities, actual or prospective. And I then go, please, to paragraph 47, the judgment of Lord Hope. After analysing with considerable care the real scope of the de minimis principle from paragraphs 44 to 46, paragraph 47, right down the bottom at H, the policy does not provide clear guidance as to where the line is to be drawn between effects which are and are not negligible, but it can at least be said that an injury which is without any symptoms at all because it cannot be seen or felt, and which will not lead to some other event that is harmful, has no consequences that will attract an award of damages. And he repeats this sentiment, paragraph 49D. Plural plaques are a form of injury. That was what I had quoted earlier because I knew I'd be coming to it now. But they are not harmful. That was his approach, was harmful injury. But there are different ways of describing the matter, but the most helpful in our respectful submission is material damage or worse off. They do not give rise to any symptoms, nor do they lead to anything else which constitutes damage. And 50, between F and G, I would hold, however, there's no cause of action because the plural plaques in themselves do not give rise to any harmful effects, physical effects, which can be said to constitute damage, and because of the absence of a direct causative link between them and the risks and the anxiety, which on their own are not actionable. So although it's all put in a negative, it's clear that Lord Hope, in our respectful submission, is indicating that in circumstances where positively it can be shown that there has been a physical change to the claimant's body, which physical change puts that person at risk of symptoms arising along a direct causal pathway from the physical change, not separately. That's the plural plaques problem. It says your risk of mesothelioma was not a risk arising out of your plural plaque, it was a risk arising out of exposure to asbestos. But of course, the platinum allergy is no more, no less than, as Dr. Rudd put it, symptomatic sensitization. Asymptomatic sensitization, moving into symptomatic because you call it an allergy on further exposure to platinum salts. Hence, having to grasp from the respondent's side this, but it can't be right, and we'll think of a reason why, because you have to put in more platinum salts into the equation. And these are cases, granted, in which the exposure to the asbestos occurred many years ago. And this isn't a case in which further exposure to asbestos puts them at the risk of mesothelioma, but that's because that's the nature of the claim in asbestos. But just because that's the factual matrix here doesn't change the principle. Lord Scott, paragraph 68, page 518. Between C and D, plural plaques are not visible or disfiguring. None of the appellants suffered from any disability or impairment of physical condition caused by the plural plaques. The plaques were asymptomatic and were not the first stage of any asbestos-related disease.
Well, there are two separate points, aren't there, here? One is that you say that the appellant's condition could develop, given exposure, further exposure, into a more serious medical condition. But Lord Scott also, in the sentence halfway between C and D, says none of the appellants suffered from any impairment of physical condition. And you, I think, are saying that here there is an impairment of physical condition or of bodily powers, as Master Varell's put it in the Victorian case.
Absolutely. My Lord, I am. Plural plaques case, Rothwell, in one sense, goes way beyond where we need to go to. Plural plaques were symptomless, and nothing could be said about the existence of the plural plaque itself. It couldn't be said in that case that a plural plaque caused any loss of utility or function of the claimant's body. It can in our case, and that suffices, full stop. But we also note in plural plaques that it would appear from the passages that I've referred the court to that we are in a situation akin to the Knapp, to the Bell case and so forth, in which if you have what I might describe there as a contingent loss, first stage of the process. I could choose to use that language. I know I would immediately be hit with nigh credit and so forth, and law cite in Sefton, but I could describe that as a contingent loss. Although a pure contingent loss doesn't suffice per Lord Hoffman in Law Society in Sefton, we have to understand quite where the courts have been prepared to draw the line before it's described properly as a pure contingent loss. And they draw the line very early. So in fact, we pass that threshold with ease because we have our loss of amenity with platinum sensitisation. A person with plural plaques can't say, tomorrow I can't do what I could do today. But arguably, Rothwell goes further. My lady, I now make my 9th submission, which is the courts are prepared to embrace contingent financial loss when considering whether someone is worse off in the personal injury context. This is all part of our subsidiary case, as opposed to our principal case. And first of all, can I go back to Rothwell and Lord Hoffman, paragraph 7. So that was 13501. And the sentence that I first read out from paragraph 7, damage in this sense is an abstract concept of being worse off, physically or economically, so that compensation is an appropriate remedy. I would well understand that it could be said that is Lord Hoffman speaking at a higher level of generality before Lord Hoffman moves to consider the context of a personal injury claim. But that's certainly not how my learned friend had read that passage either when he made his submission in Carder at paragraph 17. That's back to 19639. So it's page 639, we're in Carder.
639.
639, my lady, I'm sorry. 19639, para 17, Mr. Kent submits the judge, one should have concluded that while the defendant made a material, though very small, contribution to the asbestosis, this had made no addition to Mr. Carter's disability and had not caused him to be worse off physically or economically. No doubt drawing from paragraph 7 in Rothwell in a personal injury case of asbestosis. Be that as it may, it's obviously a matter for the court to consider Lord Hoffman's intentions in paragraph 7. In our respectful submission, he was indeed considering the context of the appeal. Secondly, can I go to Lord Roger in the Rothwell case, paragraph 86. And Lord Roger had homed in on a Scottish case of Brown and North British Steel Foundry Limited. So this is 523, 13523, paragraph 86. And this was the precursor to his summary paragraph 87. And he had quoted approvingly from Lord President Clyde, who'd held that there was no cause of action in 1949, and who'd added, to create a cause of action, injury and damnum are essential ingredients. In the present case, there is no evidence of any injuries to workman's lungs in 1949. He had then merely a deposit of dust in his lungs, which might or might not subsequently create an injury. But in addition, he had then sustained no damnum. He could not then have been awarded damages for any loss, because at that stage he had sustained no loss of earnings and had suffered none of the discomforts and disabilities which he avers followed upon the onset of pneumoconiosis, which in fact flowed from the outbreak of that disease in 1955. I would accept it's difficult. It's a difficult issue to determine, and these are indicators from the court. I don't suppose for a moment they would be deemed to be binding, the observations from Lord Hoffman and Lord Roger in this context. But the indications from both judges, in my respectful submission, is that loss of wages, economic loss, is something which is relevant to the court's assessment of whether or not the cause of action is accrued. Can I briefly dip into the McFarlane and Tayside case? Again, a case that can be easily distinguished on one basis, no difficulty with that. It's having very little, in one sense, to do, and in another sense, quite a lot to do with the issue here. It's 321, and it's the wrongful birth case. Not wrongful life, but wrongful birth, a claim by parents for the economic costs and or damages for personal injuries associated with a mother who gives birth in circumstances where the desire of mother and father had been that they would not conceive. Breach of duty by doctors, they do conceive and they have a healthy child. Can I just go to page 1222? The majority held that there was a personal injury claim that could be supported for the mother. Lord Millett didn't, but only for reasons that he subsequently addressed at 1229. But for these purposes, he was satisfied of an accrual of cause of action. We see this down at G, so 1222G. The damnum occurred when Mrs. McFarlane conceived. This was an invasion of her bodily integrity and threatened further damage, both physical and financial. There's quite a lot in that sentence. It reiterates the essence of what it is to bring a claim for damages for personal injuries, which is in response to a reduction in the use of your body in bodily integrity, and would appear to recognise that threatened further damage is relevant to when the damnum occurs, and also threatened further financial, as opposed or include as well as physical loss. Can I now go back to cartilage, but to cartilage in the Court of Appeal? There's a passage in the judgment of Lord Justice Pearson, which has been read one way by Mr. Justice Jay, another way by Lord Justice Sales, and I hope to persuade the court that it should be read in the only natural way it can be read, as Mr. Justice Jay himself recognised. Can I take you to the passage, please? It's at page 941, so 1, 2, I think I said 491, I'm sorry. 1, 2, 491. The paragraph is the paragraph in the middle of page 491. And before I make submissions, may I invite the court to read that middle paragraph starting in deciding whether a cause of action had accrued. My lady and my lords, that is, in our respectful submission, an insightful passage which starts with the words, in deciding whether a cause of action had accrued. Ergo, it cannot be interpreted as Lord Justice Sales deemed it should, as simply doing no more than confirm the standard position as he described it, and I'll go to his paragraph in a moment. The paragraph was concerned with determining whether or not there was damage. That was the purpose of his analysis, because he set himself the question in deciding whether a cause of action had accrued. And what Lord Justice Pearson has recognised is that a person who understands that he is in a position of having a bodily change which is liable to affect him by continuing to work, has had his position changed. It's had a real effect on him. It has caused loss of amenity, such that if he then elects reasonably to give up that work, he should be entitled to recover either, as my Lord Reader's put it, consequential loss, or he should be able to recover damages for his financial loss, which are part of determining that he had a cause of action for damages for personal injuries. So it's a highly relevant passage, full stop. It supports, in our respectful submission, the contention that financial sequelae or consequences are a relevant factor in determining or deciding, as he put it, whether a cause of action has accrued. And certainly, Mr. Justice J, when we go back to the core bundle, paragraph 24, which is at page 187,
Is it financial sequelae or is it financial risks, really?
well, they are future, and therefore you could use the word risk, because that's why I don't shy in some contexts from saying you could describe these things as contingencies. It's possible to describe them in that way. And that's how we see it, the matter approached in some of these examples. But here, there's a night follows day element to it anyway, if the court says, well, I must take into account, per the respondent's case, that this person was bound to be found to have a positive skin prick test and bound to be taken off the job. That's the source for the goose is sauce for the gander. If that's so obvious and so clear, then they're also going to suffer the economic consequences. Or put a different way, if they do suffer the economic consequences these claimants say they have, that suffices. Paragraph 24 in the judgment of Mr. Justice J is at page core bundle 187, and the way in which the learned judge put it was right at the bottom of that page. It is also true that Pearson LJ, so it's page 187, Pearson LJ appears to have regarded a reduction in future earning capacity, in answer to the question of my Lord Wilson. I mean, that's how Mr. Justice J puts it. Future and capacity is his choice, as being a salient feature of the injury. Lord Justice Sales did not agree, and we see this in his paragraphs 16 to 17, starting at page 27, so core bundle 27 to 28.
Sorry, paragraph?
My Lord, it starts at paragraph 16 on page 27, and his analysis continues to paragraph 17 over the page 28. And again, the whole of that can be read. Obviously, I don't wish to keep the court out of reading that, but can I just...
Well, you can probably assume we've already done so.
I'm very grateful, my lady. In which case, can I go straight to paragraph 16, right at the top, after he says, I don't think the passage assists the appellants in discussing the scenario set out in it. Pearson LJ was explicitly making the assumption that there was injury to the plaintiff's lungs, that is to say, a physical injury sufficient to complete the relevant cause of action in tort. That single sentence suffices to draw out what with the greatest of respect is where the Court of Appeal went wrong. The test, as I've sought to show, involves considering first whether there's a bodily change or physical injury or such like expressions. Two, which causes the claimant to suffer material damage or to be materially worse off. Whereas the approach of Lord Justice Sales throughout was simply to say the test is there a physical injury? Which he has plainly equated with symptoms. And he repeats it time and time again. And I'm going to give you the paragraphs. 10, this one, 16, 32, 53, and 55. His bright line test, as he describes it, is simply the wrong test. He describes para 55, page 39, the appellants could be said to be just on the wrong side of a reasonably bright line rule according to which the threshold for liability is the infliction of physical injury. It's as if cartilage doesn't exist, because he's waiting for platinum allergy, which never comes, and therefore the claimants are wrong in its mitigation advance and so forth. My lady, it's not so very surprising that the court should have regard to financial consequences of a bodily change. Chief Justice Posner in the Miller and US Steel Corporation case, which we have at 761, 2821, right-hand column at the top.
Which bundles?
7, my lady.
Thank you.
761, 2821, right-hand column at the top. I probably should take it from left-hand column at the bottom. The millers are attempting to use tort law to recover the cost of replacing a defective product sold to them for use in their business. The cost is called in law an economic loss, to distinguish it from an injury to the plaintiff's personal property other than the product itself, the type of injury in which the product's liability suit usually is founded. It would be better to call it a commercial loss, not only because personal injuries and especially property losses are economic losses too. They destroy values which can be and are monetised. The whole process of restitution is to provide a money compensation for an injury. It's not so surprising that the court should have regard to the financial consequences. If I can, by way of example, postulate a modest cut to someone's face. That's a physical change. Is that claimable? Should that fall within the de minimis principle? Well, you ask the question, what is the effect upon the individual? And if the effect upon someone who is not in their first flush of youth is modest indeed, so be it. If the effect on a model is that the model cannot go and work the following day for this tiny scratch on the model's face, is that not an issue which the court can take into account when determining whether that person's scratch constitutes damage for the purposes of an action for damages for personal injuries? It's not such a stretch. None of this is necessary for our case, I'm at pains to add. But this is part of our subsidiary submissions. It all comes back to asking the same question. Has there been a diminution in the use or value of the claimant's primary asset, namely his body? So, my lady, these appellants underwent a bodily change by developing platinum salt sensitisation. And the court cannot divorce that bodily change from the consequences to which it exposed those appellants. Because on being sensitised, they needed to avoid circumstances in which they were exposed to platinum salts, or else suffer the consequences, namely symptoms. Asymptomatic converting into symptomatic sensitization or platinum allergy. They were set on the path to allergy. And in a very real sense, that constitutes actual loss of immunity or loss of capability, which is why I've made no submissions at all on de minimis principle as carefully analysed by Lord Hope, because it's just not in play here at all. It's so obvious the effect it's had. Their capacity to continue in their ordinary lives, their ordinary activity of work, was compromised on sensitisation. My lady, the collective agreement under which the employees were subject to regular skin prick tests simply cannot change that analysis. The answer to the case should not be different if, for instance, an employee was working in a platinum salts factory exposed in breach of duty to platinum salts, developed platinum sensitisation, there being no collective agreement in place, goes off and for whatever reason ends up having a test, discovers that they are platinum sensitised, and the employer then says, well, we're going to remove you from the red zone area. So the mere fact you have a collective agreement in advance setting out what will happen in certain circumstances cannot bear that weight of changing the outcome between those two cases. All the collective agreement does is to confirm what happens after sensitisation and sets out what should happen as a result of sensitisation. In just the same way, as nor should it matter if the individual employee, having gone off his own bat and obtained a skin prick test, discovered he's sensitised, notifies the employer, says, well, it's very interesting, but carry on. And the employee then chooses, as an act of responsible mitigation, to give up his work in the red zone. That would be your Pearson LJ example, in which exactly the same position is reached, because it all flows from the platinum sensitisation, not from the collective agreement. So there is no need to trespass into the yet uncharted waters of something called mitigation in advance of loss of injury. We don't need to go there. In the same way, and this is an example I think we've given in our appellant's case, that if there was a financial cost, so the appellant, having discovered that he's sensitised to platinum salts, whether through a collective agreement arrangement, whether of his own bat matters not, then learns that in the States, for instance, there is a potion which can be taken which should have the effect of reversing this outcome and thereby allowing him to continue in his work. That feels, quite rightly, like a classic case of mitigation. That can be deemed to be financial cost completing cause of action, but in fact on our primary case is nothing of the sort. It's mitigation after the event. It's incurring a financial cost to put the claimant's body back into the position it should have been in, but for the defendant's negligence. The complete body, the unmolested body. So that's the case. My lady, may I start on our backup case?
You may, if you wish to do so.
Well, I do, because only because, my lady, I have only till 3 o'clock.
Well, you don't have to take all the time till 3 o'clock if you don't need it.
My young lady's very, very grateful, but I would certainly wish to get started now, if I may.
Yes, by all means. Yeah.
So, my lady, this set of submissions proceeds entirely on the basis that we are wrong as regards actionable personal injury. So I now argue against myself vis-à-vis that, as opposed to make endless concessions about our case. My lady, here, the appellants are seeking to recover what might be described as preventive damage. The claim arises where, in breach of a duty to protect an employee from damages for personal injury, an employer causes an injury, bodily change, but not at that point one that suffices to cause material damage to the claimant. It's an injury or bodily change, but it's not an actionable personal injury position. And in circumstances where if the employee were to continue in his job, his injury would be liable to cause him symptoms and material damage, so that he is required by his employer, in order to prevent that outcome, to give up his chosen occupation. So if the employee in that situation then incurs foreseeable financial loss to prevent such personal injuries, damages materializing, he should be entitled to recover for such financial loss or expense. That is the case that the appellants are promoting. It is not a case for a new general duty on employers to protect the economic well-being of employees in all cases. Far from it. It involves an extension of the law in that just such an implied term has not been recognised by the court to date. But the appellants submit, if I can put it this way, the mood of the higher courts is very much to recognise that this would provide a just result. I'll seek to support that by reference to the obiter dicta set out in our appellant's case. My lady, the appellant's claim can be framed either as one for breach of an implied term imposed by law, in particular confined circumstances, as set out in our case at paragraph 49, which I'll just give it a reference, is page 85 of the core bundle, or the breach of a duty of care owed to protect the appellants from financial loss in the same confined circumstances. The appellants are relying on the circumstances of the case generally, and the existence of the contract in all its terms, including the collective agreement. They're not relying on particular representations from the employer to the employee, and therefore this is a case in which we accept that we stand or fall together on implied duty or duty of care, because we don't have any particular additional features than those features which emerge from the contract and the manner of the work. So we can take those simply as one, and I may change at points, my lady, between duty of care and implied term, but they're the same argument, identical argument, we accept that. My lady, can I start with the test which is to be applied? The term which the appellants contend should be implied into the contract of employment falls within the second type of implied term, as explained by my Lady Hale in Gaze, a case which is in bundle 5, tab 41, at page 2058. Paragraphs 55 and 56, page 2058. Paragraph 55, my Lady Hale explained that there is the standard implied term to give business efficacy to a contract. And second, E, there are those terms which are implied into a class of contractual relationship such as that between landlord and tenant, or between employer and employee, where the parties may have left a good deal unsaid, but the courts have implied the term as a necessary incident of the relationship concerned, unless the parties have expressly excluded it. At paragraph 56, my lady considers the judgment of Lord Justice Dyson in the Crossley case, and there is an issue between the parties as to the weight that should be attached to that judgment. And can I invite the court to read the remainder of page 2058?
Some of us have just been reading it in another context.
Well, lady, I don't know to what extent that context impacts here, but in any event, your ladyship concluded there's much to be said for that approach, and I would invite the court to go a stage further and approve that approach for reasons which I probably can develop in the next 5 minutes before the luncheon adjournment. The concern of the respondent, as I understand it, is that the key word is necessary, and that should not be watered down, as Lord Dyson has sought to do so in Crossley, by converting it into reasonable, just and policy issues. Our submission is that Lord Dyson understood precisely what he was indicating and was right to draw the court towards what's fair, just, and I would describe reasonable, fair, just, and reasonable when making its assessment. On a standard between the parties implied term, the first type, of course the court is not considering what might be a reasonable term for the parties to agree. The court is not considering that. That's well known. The court is considering what is necessary to imply to give business efficacy to the intentions of the parties. So there, reasonableness has no place. In the second class of implied term, however, the court is not striving to identify what the parties have intended. The way in which the matter is put by Lord Newburger in the Marks and Spencer's case, which is at 649 2405, paragraph 15, so 2405, he draws attention to Lady Hale's observations in Gaze. He notes that the Marks and Spencers is a first type of case, standard between the parties, business efficacy. He continues, the second type of implied terms arises because, unless a term is expressly excluded, the law, sometimes by statute, sometimes to the common law, effectively imposes certain terms into certain classes of relationship. And can I emphasize the word imposes? So the court's not striving to identify what the parties intended. It is effectively imposing certain terms. And the test can, at first blush, be said to be one of necessity, and see, per Lady Hale, at para 55 in Gaze, as a necessary incident. But the question then arises as to when and why the court would consider it necessary to impose such terms upon the parties. And the answer to that question lies by asking, is it fair, just and reasonable to impose these terms? You can't, it's a point Lord Dyson makes, how can you work out that it's necessary to do these things? Even as he says, even to have the implied duty to take care for the health and safety of the employee. Necessary is, sorry, my lord.
Well, I was going to say, I see my lady cited at the end of paragraph 55, the Liverpool City Council case. That's, speaking from recollection, Lord Wilberforce's approach is a world away from considering what's fair, just and reasonable. It put, my recollection is a much stricter test.
Well, my lord, there has been, and I'll make these submissions in the afternoon, there has been an evolution in the employment context, an evolution by the imposition of implied terms, So one can say what was necessary then or deemed necessary in those social circumstances is not what's understood to be deemed to be necessary now. One can or cannot lose the word necessity. In one sense, we don't mind. But the court still has to answer the question, and by answering the question, the insight of Lord Dyson is you're really going back to the same issues. You're saying, is it appropriate for the court?
If we're in the realms of imposing things, isn't it really better to look at it in terms of tort rather than contract?
My lord, in many respects, absolutely. And that's why we come full circle, because if we look at our claim, which runs equally as an implied term in contract imposed by the court and as a freestanding duty to protect from economic loss in these circumstances, we end up with our three-stage Caparo test, the third stage of which, is it fair, just and reasonable? And we might say impose or to place or to determine that it's always existed as a matter of common law. But the court shouldn't be in a position where to get to the same result by two different routes, it applies two different tests. So, my lord, yes, that is our submission. Lady, would that be a convenient moment?
Spot on.
Very grateful.
So I go by the clock on my computer because it's slightly more reliable. Anyway, we shall look forward to hear you further at 2:00.